Welcome to Bloomberg Law. I'm Pacchia. We're joined today by Derrick Cephas. He runs the Financial Institutions Regulatory Group at law firm Weil Gotshal. In a former life, he was the president and CEO of Amalgamated Bank based here in New York City, and he also was the Superintendent of Banks for the state of New York. Suffice to say, this man knows his banks. Thanks for coming in. Welcome.
Thank you very much.
This is a really interesting time to be talking about the banks. Last week we saw a proposal released on the Volcker Rule. It's going to go into an extended comment period that should conclude, I believe, in mid-January.
Right.
And then hopefully we'll have the final version of the rule coming online mid-July of 2012. What to make of this rule at this point in the process?
Well, you know, it's one of the major pieces of dodd-frank. Probably.
So it's a big rule embedded in a very big law. It's probably very hard to unpack this.
Correct. But I think it will have far-reaching implications.
We'll get to that in a moment. But first, I want to talk to you about the policy purposes behind this part of dodd-frank.
Right.
What is Congress going for here?
Well, I think the thought at the time was that they wanted to remove some of the risk from the banking system. They wanted to, in a way, bring the banking system back to a simpler time and continue, I think, the effort that you're going to see now of separating commercial banking from investment banking, taking banking back to its more traditional roots.
Do you think there was a political reason that they didn't go farther, back to something like, say, Glass-Steagall, for example, say a hard and fast breakdown of the universal bank model, to something where we have them in completely different enterprises, investment banking on one side and commercial banks on the other? Do you think it's purely a political question at that point, or do you think that there was something else at play?
Well, just reading the various commentary at the time, I think it was a difficult public policy question. You know, some people argue that, you know, the Volcker Rule itself goes pretty far. Not certainly back to dividing up commercial, not back to pre-Glass-Steagall, but it's quite a step to go this far, I think. And part of it, I think, what the Congress was trying to do was remove a significant amount of risk from the financial system and bring about greater stability. I think it would be hard to really turn back the clock entirely to pre-Glass-Steagall.
Because the system is just so complicated and kind of has developed in a way that just makes unwinding it
I think
impossible?
So.
Are we past the point of no return?
I think it's going to be very difficult. And in fact, it may not necessarily be the best thing to do, even if it were possible to do it. From a policy perspective. It remains to be seen, even if the Volcker Rule will work, if it'll do what it set out to do. But I think to actually go back to pre-Glass-Steagall, when the securities and the banking business came together, that probably is a stretch.
Let's talk about the rule itself. Unpacking it, the basic requirements seem to revolve around the idea of banning proprietary trading in the banks.
Correct.
Let's define prop trading.
Prop trading is a bank trading as principal for its own account and trading in securities, buying securities, selling securities for a profit and for their own account. They take the loss, they take the gain, not acting as agent, not acting as a broker. That's basically proprietary.
There seems to be some difficulty even amongst regulators and the industry as to what exactly is going to be termed prop trading, because some, I guess, business operations in banks are hard to define under these rules. I guess that's going to take up a lot of the rulemaking period, that internal debate, or is there something else at play?
No, I think it will. The rule is enormously complex, 300 pages and very complicated set of rules. Proprietary trading, it's fine. You can define it with a set of words, as we just did. But when you get down to practice and how do you live with that every day in terms of implementation, I think it'll be difficult. They have, in the rule, there's an exception for market making. There's an exception for underwriting, which makes sense. But again, I think there's going to be a significant amount of pulling and tugging on those two matters specifically, and how you define those. Are they sufficiently clearly defined, and where you draw the line between proprietary trading and, say, market making or underwriting? And it's really not a bright line. It's not so that's what's going to make implementation and enforcement and monitoring quite difficult.
Other than prop trading, what else jumps out at you when you take a look at Volcker?
Oh, there's the other side of it, is where it divides or it prohibits banks from owning or sponsoring a hedge fund or a private equity fund. And again, I think analytically, that's probably less difficult than the prop trading portions of Volcker. But there, I think the impact on the banks will be no less significant.
What about the impact on funds? Is that going to completely revolutionize the hedge fund and private equity space, having banks out of that?
Well, I think so. What's going to have to happen is the banks who now are affiliated with private equity funds or hedge funds are going to have to end those affiliations for the most part. There is a de minimis rule, but for the most part, there's going to have to be a divorce. And the private equity funds are going to have to find their sources of funding someplace else. So there will be some, I think, realignment and readjustment in that regard.
Let's talk about enforcement. Once this rule comes to be, it seems as if a number of regulatory agencies are going to be charged with enforcing it. Who's going to lead? How is this going to work? What to make of the enforcement side of the picture?
As the rule exists right now, I don't think there's a clear picture on that. Typically what happens is the primary regulator of the institution, through the examination process, will take the lead in enforcement. And then you have, and in the way the reg reads right now, there's a significant compliance element to it, where banks have to keep records, they have to demonstrate that they're in compliance, do a lot of training and policies and procedures and all the rest. And I think through the examination process, the primary regulator will make a determination as to whether or not there has been compliance. And then the question is, if there has not been, what the appropriate remedy is.
So, stepping back, we have this long rulemaking period, this long commentary period. In the meantime, what are you telling your clients? What should banks be doing in order to prepare for a rule that we really don't have the broader contours for as of yet?
Well, it's been out a couple of weeks, and it's so complicated, so dense, and we've spent a lot of time with clients just kind of helping them understand what the proposed rule is. Remember, this is a proposed rule, not the final rule.
Right, the final rule is probably going to be a little bit different and potentially very different.
Right, and so even in the proposed rule, as I said, 300 pages, but the regulators themselves pose about 400 questions in their proposed rule. They set out a section of the rule and they say, here's the proposition, here's what it says right now. And then there's 10, 15 questions. Did we do this right? Did we do that right? Should we change this? Is there another way to approach this? So the regulators, I think, even in this part of the process, acknowledge themselves the complexity of this and the fact that many of these questions could be resolved one way or the other.
Is this rule workable?
Hard to say. Hard to say. I say that because, to me, there was a policy judgment in passing this rule. This rule clearly is going to be detrimental to the banks. I don't think you can argue against that. The question is, will the rule produce enough additional stability or improve and enhance the stability of the financial system enough to make the trade-off justifiable? And so if that's the case, if at the end of this the rule works, the rule produces a stability, removes a lot of the risks that the Congress and the regulators hope it does, then maybe the trade-off would have made sense.
I guess the other question, apart from whether it's workable, does it hit the mark? Does this fix the problems that exist in the banking system? I mean, we're living in a time where a lot of people are very concerned about our broader financial system. And we had thousands of people protesting in Times Square, specifically about the way banks in this country operate. Does this rule hit the mark?
Well, I think in part. This is an incremental change, and let's hope that it does some benefit. But I don't think we can say that it will remove all risk from the banking system. Certainly will not, because there are many, many other types of risks and types of products that banks offer.
We've heard a lot over the last couple of weeks about almost the inherent nature of the universal model is that it privatizes gains that the bank makes, but it socializes the losses by the virtue of having consumer deposits on their books. It effectively puts the government in a position where it needs to step in anytime there's a catastrophic loss at a bank. Is there anything in Volcker that fixes that problem?
No, I don't think so. I don't, and I think that's a problem you're going to have in a complex environment like we have, and also an environment with very large institutions. Volcker does not fix that problem.
Is there any way to fix it? Is this just our reality?
Yeah, I think it's our reality. I think that you can have banks fail, and you can wipe out all the equity of the shareholders, And I think there's nothing wrong with not protecting the shareholders. They take that risk. But I think to preserve the stability of the system and to have an orderly wind down of a troubled bank rather than just let them blow up and all the systemic risk that brings. And some of that is going to be, I think, protecting, the institution. Protecting individual institutions as a byproduct of stabilizing the system.
All right.
I think that's where we are now.
Well, we're going to be talking about this for a long time, and I hope you come back and fill us in on Volcker as we see more and more of it come into reality.
Great.
Thanks for coming
Love to. Thank you.
That's Derrick Cephas. He runs the financial institutions regulatory practice at the law firm Weil Gotshal. For more information on the issues we just discussed, be sure to check out our banking and finance law report. It's available on BloombergLaw.com. I'm Pacchia. Thanks for watching.